So this paper is a joint paper with Dr. Mark Wilkinson, who is a pathologist at the University of East Anglia and the Norfolk and Norwich University Hospital Trusts. And it arose largely because of some experiences that he had as designated individual under the Human Tissue Act at the institution he works at. Over the 8 years as DI, he's had 5 requests for paternity testing on archived tissue after the father has died. And it turns out, when we looked at the case studies, to have shown some interesting issues about the way in which the Human Tissue Act and the Human Tissue Authority guidance conflict and the impact on the individuals concerned. So what I'm going to do is just talk a little bit about the case studies, do a little bit of, try not to do too much of a hatchet job on the Human Tissue Authority, but you might pick up some concerns. So the first thing to say is that all of these cases are people with misattributed paternity, and we did a little bit of mathematics and we worked out that there are about 26,000 cases of misattributed paternity each year. And most of them will never know. Most of the ones that do find out will solve the issues about knowing before anybody dies. But if our sample is, if we can extrapolate from our sample, you're looking at about 100 requests for paternity testing after somebody has died each year. So it's a relatively small problem, but it, as I will illustrate, it is something of a problem. It may not be done until after death, because the information may not be known until somebody's died. One of our cases is a case involving a deathbed confession. And it may also be triggered by paternal relatives, perhaps not happy about this grandchild who might be seeking inheritance or relationship type issues. So there's a lot of why is it arising and those sorts of questions. The legal framework is to be found in the Human Tissue Act, and it's under section 45, which is the non-consensual DNA analysis section. If DNA from tissue is to be analysed, you need qualifying consent. That is either the consent of the deceased person before they died, or the consent of somebody in a qualifying relationship. On the slide is the list of qualifying relationships, which is found within the Human Tissue Act. Now, for those of you who know the Human Tissue Act, this list is usually treated as a hierarchical list, and you have to seek consent from somebody the highest up the list possible. In the context of DNA analysis, which also has UK-wide application, and not just England, this list is non-hierarchical. So consent from anybody in any of those relationships is sufficient to act as qualifying consent for the purpose of this section. The ultimate decision to offer the test in these circumstances is made by the designated individual at the NHS Trust, who is in charge. The Human Tissue Authority have issued some guidance, which is available publicly on their on their website to anybody who searches for it. And they say that the consent that is necessary is from somebody in a qualifying relationship with the deceased, and the emphasised bit is my emphasis, who was close to the deceased at the point of their death. Now, it sounds like a tiny, tiny conflict that makes no difference. It's vaguely interesting, but ultimately pointless to really talk about. Well, we've got 3 case studies, and what I'm going to do with the case studies is just illustrate the impact of this apparently minor conflict. So case 1, multiple partners. We've got Mr. B, who is deceased and appears in the mortuary of my colleague. Miss A contacts the DI and asks for paternity testing for her child, Master AB. All going absolutely fine. So the decision is approved, or the test is approved by the DI. Miss A is a partner of Mr. B and so can give qualifying consent under the Act. Just before the test is carried out, the solicitor for Miss C contacts our designated individual and says that she's refusing the test, and she's refusing all tests to be carried out on Mr. B because she was also his partner and also had a child with him. Miss A and Miss C, they essentially spent half the week with Mr. B. He moved between them. Neither of them knew about each other until after his death. So, what do we do? Well, the DI decides that there are good reasons for both children to be tested because this is in fact being triggered by Mr. B's parents who are questioning the paternity of the first child, and the logical conclusion is if they challenge the paternity of the first child, they may well challenge the paternity of the second child, get both children tested against Mr. B's tissue. So that's what they do. Miss C agrees to this, and that's the decision. If you look at what the law says, then because the list in the Human Tissue Act is not hierarchical, consent from any person in any relationship is sufficient to authorise the test to go ahead. It doesn't matter if there is two people in the same relationship. And so, on the basis of the law, the test could have gone ahead with the consent of either partner. There's also the approach taken in the Act is that consents have priority over refusals. So her refusal, Miss C's refusal, couldn't veto the test going ahead on the basis of Miss A's consent. The guidance adds the extra requirement of closeness at the point of death, which leads to some kind of complicated analysis of whether the person who got to spend 3 days of the week with him had a closer relationship than the one who spent 4 days a week. It's also not even clear if it matters to do this relative balancing. So what we've got is, it just adds a bit of confusion in this situation. So that's the first case study. The second one. In this case, D was an adult. Oh, in the first case it's worth saying that Master AB and Master BC were young children. In this case, D is an adult, and his father is deceased. On her deathbed, his mother, Mrs. D, confesses to having had an affair at the time of his conception, and she is now not sure, she hasn't been sure that his father is in fact his father for the whole of his life. And this is obviously, she needed to tell him at this point. She has other children, so he has sisters with whom he has a difficult relationship, and the sisters were never told about the mother's affair, so there's sort of family secrets going on as well. On the basis of the law, D is the child of his father, and if we look at accepted principles of family law, the presumption that somebody is your father if they are named on your birth certificate holds until it is actually rebutted in a court of law. So that's the situation. So D is in a qualifying relationship for the purposes of the law, is able to authorise the test with his own consent. On the basis of the guidance, well, if he was close to his father at the time of death, that's also fine. The Human Tissue Authority, when our designated individual rang them up to ask what on earth he did in this situation, they said that this would be a case of non-consensual DNA analysis, so that they refused the test, refused to allow the test to go ahead. Their reasoning was that by asking for DNA analysis, paternity testing in this sort of situation. Doubt was cast on the existence of the father-son relationship, and so it was to be treated as if it didn't exist. So it wasn't there. There was no qualifying relationship for the purpose of the human for the purpose of the act. Now he could have contacted his sisters to ask them to give consent in this situation, but given the practical issues, he felt that that wasn't appropriate, and the test was never carried out. So we've got quite an interesting conflict there. The final case, this one is a little bit more complicated, so just forgive me if I, stop me if you've lost me. So Mr. G has died, and throughout his life and in his will, he recognised Miss E and Miss F as daughters, and they were identified by name as daughters in his will. He was not named on Miss E's birth certificate as her father, so that's, and we don't know what Miss F's birth certificate said. But there was a relationship throughout their lives as father-daughter. Miss E was very close to Mr. G. She was with him throughout his last illness and was there when he died. So close personal relationship as well as any acknowledged relationship. So after Mr. G's death, Miss E and Miss F appear at the designated individual's office to ask if there was any way to test the paternity of Mr. G for Miss E. They go through the discussions, they talk about the relationships. He concludes that they are in, the relationship in life indicates a father-daughter relationship, which is sufficient for a qualifying relationship at law, and so he decides it's okay to do the test. The test is done. Miss G, who is Mr. G's sister, then complains about how it is possible for somebody who doesn't have Mr. G's name on their birth certificate to have consented to paternity testing of Mr. G. And so at this point, they go to the Human Tissue Authority and say, oh God, what have we done? The answer from the Human Tissue Authority is, actually I'll come to that in a minute. So on the basis of the law, it's probably not okay for Miss E to give consent as daughter because Mr. G is not named on her birth certificate, so there's no legal relationship. But being named in the will, that's something that might be enough to rebut a presumption if necessary. However, also on the list of qualifying relationships is friend of long standing. Now, even if Miss E is not a daughter, however you define friend of long standing, somebody who has been involved with a person for a period of time throughout their life, looked after them in their last illness, was there at the time of their death, is probably a friend of long standing. So, certainly at the law, she is entitled to give consent on her own behalf under that part. The authority guidance works in the same way. If anything, she's even better qualified because she can show closeness. Again, if you've held somebody's hand while they died, you probably qualify as close. So she can give consent on her own behalf on that basis as well. What the authority said is that Missy couldn't give consent at all because the doubt was cast on the relationship. It was so similar to Mr. D. If doubt has been cast on the relationship, it's treated as not existing, and so that consent can't be authoritative. But Miss F, who was in exactly the same position as Miss E, could give consent to authorise the test because she wasn't asking for testing for herself and had therefore not cast doubt on the relationship with Mr. G. But so that's fine. So we've got some really complicated jiggery-pokery, I think is the best way to describe it in this situation. It's really arbitrary reasoning, which, you know, there's no difference between the two. It's just that one party has asked for testing and the other one hasn't. So what we've got, this is the table that we put together, in our three cases, the law is very clear. You know, that if we use established principles of family law to identify relationships between people, then everybody, there's a qualifying relationship in all cases, in all of these three cases, and consent could have been given just on the basis of the law. The authority guidance adds this extra requirement of closeness, which actually just makes things more complicated, because they give no additional guidance on what closeness actually means, and so you're left with this actually really uncertain concept. It's also worth noting that the authority can't prosecute somebody for breaching a term of their guidance. So they've added an extra requirement which can't be used in order to consider whether somebody can be prosecuted under the section. So that's a whole other, it's a relevant issue. And then what we've got is when you ring them up to ask them for advice, they say something that's completely in conflict with both the law and the guidance that they have published. And in one case, Mr. D, he was denied access to a test completely, even when on the law he should have been allowed it. So we've got a really stark conflict, and we think that this conflict has implications for two groups of people. I'm conscious I'm waffling on a bit. The individual seeking testing, there will be some people who are denied tests by the authority or on the basis of the authority's guidance when it would be lawful for them to be allowed it. There's no redress for that, there's no way of appealing that unless you go through public law and ask for a judicial review of the decision, which is a big undertaking, probably not something that your average individual seeking testing is going to be aware of. Most of them won't be represented by solicitors, and so even then, so there are going to be a lot of people who can't get testing when they want it. There's also a significant impact on the designated individuals who are stuck making these decisions, because they've got a law that says one thing, published guidance that says another thing, and then when you ring the authority to ask them for advice, you get told something different, which conflicts with the law and the guidance. What's also interesting is that the authority make very clear that their advice is not legal advice. So what do you do next? You go to a trust solicitor to get legal advice, who is possibly no more well informed about the Act than anybody else. So we've got kind of significant problems. And finally, just the wider argument. I think there's lots of ways to take this, and I'm at this stage in writing the paper. I think firstly there's this really odd understanding of the parent-child relationship that comes from the Human Tissue Authority's actions. So we could look at that in the context of English law. Whether there is any kind of protection for this right to know your genetic parentage, which has been protected for adoptees and donor-conceived children. And then there's something about the role of the regulator and this idea that the authority isn't going to give legal advice when actually the questions in this area are inherently legal questions on which people need legal advice. So, yeah, if anybody has any comments on where I might go with it, that would be very helpful. Thanks very much.
Thank you. Ruth, so I'm speaking to the property bit of the tongue twister title of this seminar of consent and property and posthumous paternity cases. And I've been doing some work on the case of Yearworth and North Bristol NHS Trust, and I'll be speaking to some of the broader themes about the nature of property reasoning in a seminar next week, but speaking to an audience of medical healthcare lawyers, I thought it might be helpful just to say some true and provocative things in the light of how jurisprudence, both in the case law and the literature, has developed in response to the case of Yearworth, just for 10 minutes or so. So the case of Yearworth people may be familiar with, but I'll give a little primer just in case, concerned a group of men who were to be treated for cancer using chemotherapy, and that might have affected their fertility, so they were given the option of storing their sperm in case it did affect their fertility. Due to the negligence of the NHS Trust, the sperm was, to all intents and purposes, destroyed due to a failure to top up the cooling mechanism. So the men lost their sperm, it was irreparably damaged, they couldn't subsequently use it. Some of the men happily did subsequently conceive by other means, but they sought to sue the NHS Trust for mental distress or psychiatric harm, depending on the case, and they also argued for some other harms, but as a result of the damage to their property. They also argued personal injury, but we won't dwell on that for now. So they were suing in the tort of negligence in English law, also subsequently bailment, for property damage in order to get to recovery for mental distress. They weren't claiming that the sperm had any value, they weren't seeking proprietary remedies in respect to the sperm. It was just a hook on which to hang a negligence claim because of the limits of recovery and psychiatric harm in the law of tort. So they used a relatively underused, obscure case called adhering British gas, which is what happens if you come home and find that British gas has accidentally blown up your house, and you suffer psychiatric harm as a result. Can you sue? Well, the court said yes, in that situation you can. And so the men said, well, being told that my property has been damaged and I've lost the right, the chance of conceiving my own children for the future, that's the same as blowing up my house. So effectively, that's the reasoning. So Yearworth involved quite fact-specific reasoning, and crucially, for my argument, what the court said was the men had ownership of their sperm for the purposes of the claim in negligence. They didn't decide, in the abstract, did the men have any ownership of their body, did the men have ownership of the sperm generally. So they gave they pointed out 5 factors that pointed in favour of this particular basis. So they said, the men had generated the sperm, the sole object for its storage was for their own potential future use. They were able to require the destruction of the sperm at any time. There were some duties imposed on the NHS Trust, and only the men had any real rights which correlated with those duties. Those considerations went to the question of could the men sue for negligence for property damage. The court only says for the purposes of the tort of negligence, right, for suing. So they don't say that men generally have sperm or that we generally have ownership of our bodies. They reject the Dudwell and Spence principle, which is an Australian authority that says where work and skill has been expended on a part of the body, you can acquire at least a right to possession of that. So, sorry?
So you own your tattoo?
Well, let's not heckle for now. Nevertheless, it's an important case. Lots of excellent literature. One of the best is by Graham Murray and Sean Harmon of this parish. There's also a case note written by me on the tort aspect of things called The Fertile Imagination of the Common Law. I'm still quite proud of that title. But Yearworth has generated an awful lot of literature from medical lawyers, from property lawyers, from tort lawyers. And it's a bit like Monet's views of the cathedral here, right? The same cathedral but very different perspectives. Understandably, because this has been a long-standing debate in the medical law literature of the role of property, if any, with our bodies, people have really taken and run with it. What I would argue is that the very narrow use of property reasoning in Yearworth is unsatisfactory on its own terms. It's not a thing to say you have property for one purpose only of suing in tort. Yes, you might have property for some purposes but not others, but you can't conjure up solely for the purpose of suing in tort a new kind of property-ish right. It's not really property, but we're going to let you sue, so we'll call it property just so you can get around that. Right? That's not a valid use of property reasoning. If you're concerned about whether people should be able to sue in these situations, modify the laws of tort. Right? They don't distort the rules of property as they apply. Graham Sean's article points to Yearworth as being a case of pragmatism, but I think it's also somewhat more dangerous than just we don't like that one piece of decision making, precisely because of the posthumous paternity cases in our title. Yearworth has been cited very little in England and Wales since it was decided 5 years ago, both times purely incidentally, not in any context concerning property in the body, just as an example of the law sometimes being a bit tricky. That's essentially first instance decisions as a throwaway reference. It has, however, been cited quite a few times in Australia. We've got more or less one decision per state: South Australia, New South Wales, Queensland, and Western Australia. And those are in paternity cases. Now that's one step removed from Yearworth, right? In Yearworth, it was the men themselves suing in respect of damage to their sperm in negligence, and they were held to have enough of a property right to sue in negligence. In the group of Australian cases, which do differ somewhat on their facts, for example, as to whether in the first case the man had already stored the sperm before he died. In other cases, it's over whether sperm can be extracted post-mortem. But all those cases involve the partner seeking to claim the sperm. And for that analysis, in order to subsequently use it for fertility treatment, there the reasoning in Yearworth can't necessarily help us, right? Yearworth can't stand as an authority that we always have a right to possession or we always have a right of property in our sperm, because all Yearworth did was say, well, we want the men to be able to sue in negligence, so we're going to treat them as having a property right for this purpose only. But what Yearworth has done in its kind of Commonwealth afterlife is there's this Chinese whispers effect of it being used as an authority for which it can't support, right? And this general property in the body. Now, the Australian cases have certainly struggled with it, but if we look to Canada, we can see the real tensions in this analysis. So in a case called JCM and A&A from 2012 in British Columbia, this concern is another case where it was held that you can have property in sperm. This was a lesbian couple who had obtained sperm from a sperm bank from a donor, and they'd each used it to have a child each using the same sperm, and there was some vials of sperm left, and then they broke up. And this was an argument over whether in the separation agreement the property in the sperm could be allocated to one or the other. One of them wanted it to be destroyed, and the other wanted her half. So these are completely different from the facts of Yearworth, because all of the reasons that I pointed to in Yearworth point to the men's essentially intimate relationship with the sperm, and also the relationship that they had with the NHS Trust. Nonetheless, Madam Justice Russell holds that Yearworth is a good authority for supporting the claim about property, even though she does recognise the different context. And that's alarming, right? We can argue over whether we should have property in sperm in that situation or in other parts of the body, but Yearworth can't be used as an authority for that, other than in the blandest sense of judges sometimes can be creative. But it's not being used in that sense, right? It's being given real normative force because it's a case about sperm where there's a property in the body conclusion. I think that is really dangerous as an instrumental, fictive way of using property. We do have a couple of other cases from Canada, one from British Columbia, where Yearworth was referred to, but it wasn't disputed that the sperm was property in that case. It was a case called Lamb, British Columbia, which actually concerned warehouse legislation, even more fascinating field. But there the argument, it was accepted that sperm could be property. It was argued over whether it could be goods for the purposes of the relevant legislation for technical reasons. And then finally, the Canadian case that fails to cite Yearworth, the case called Piljack Estate in Abraham, which was over liver tissue, but generally considering these questions about property in the body, I cite it because it should raise all of our hackles. The judge observed that it's not a simple question whether you can have property in human tissue, and also noted that neither party has provided me with any jurisprudence determining that issue, and neither party has presented a principled approach to determining the question. The judge just made do and concluded that it probably was property. So, even in cases where Yearworth could be cited and dealt with appropriately, it isn't. So I have real concerns about it, at least until we get happier lands of Scotland. So I gave this paper in September last year, and then as I was finishing it for the collection in December, a case in Scotland was decided called Holwich, Lothian Health Board. That's an ongoing case. It was decided in December 2013. Alarmingly, it won't be put to proof till 2016, I understand from counsel. So I revised my paper to take into account Lord Stewart's judgment. I actually got in contact with counsel in the case. My argument that Yearworth can't support a property analysis is more helpful for the defendant. So I sent my essay to both counsel, claimant and defendant. And counsel for the claimant said, thank you very much, pursuer, counsel for the pursuant said, thank you very much, however, because the case is ongoing, I won't be able to enter into any discussion. Counsel for the defender said, thank you ever so much for this argument. Here are my pleadings. I do hope we can correspond. So this is a good example of interaction between the bar and counsel. In Holditch, Lord Stewart does not accept the Yearworth as binding authority in Scotland, quite right, it's an English case, and also is somewhat sceptical about the reasoning adopted, and also about whether we need to use property at all here. Now, partly there's some differences between Scots property law and English property law, Scots tort of delict, law of delict, and deposit, and the English law of obligations. But also, Lord Stewart makes a quite valid point, which is, well, we can regard the sperm, the facts are very similar in Yearworth and Holditch. We can regard the sperm as a thing without necessarily needing to ascribe property rights to it. The equation of property being, this is my property, muddies together concepts of something in which I have property rights with something that is a piece of property, a thing. And Lord Stewart argues that we have an intellectual problem if we are always ascribing property rights in these sorts of situations, because we don't need to. Right? I'm very happy on the facts of Yearworth for the men to have a remedy in the tort of negligence, but you don't need property analysis to get there. Right? We can apply relatively orthodox principles of other principles of the law of tort without distorting the property analysis. And that really is my concern, not just in the medical law field, but also in other areas of property law. That property can be used in an inappropriate way, this property-ish way of saying, well, we don't want to decide these grand abstract questions of principle because that's all a bit difficult. All we need to do is decide on the facts of this case, is there property? But that's not a thing. I use that word deliberately. It's not a thing to say that it's property for this purpose and we won't worry about the others. Right? There's a responsibility when developing principles of law to have that concern for the wider implications, and especially in such a sensitive area. We can argue over the shoulds and whys and wherefores of this, and I think most of the academic literature on this area basically boils down to, well, there probably should be some sort of legislation, and you should have some limitations on any property rights if you have them. I think people, there's a risk of it being angels on the head of a pin occasionally here. But what I don't think is questionable is the proposition that the way in which the Court of Appeal reaches its property conclusion in Yearworth isn't a valid use of property reasoning in English law, and therefore we should have some concern about building broader arguments from it. So I'll leave it.